This matter is in Degliomini versus the City of Philadelphia. Representing Anthony and Karen Degliomini is Leonard Valeri. Representing the City of Philadelphia is Jennifer McNaughton.
Good afternoon. Appellant filed a negligence action for injuries he sustained when he rode into a sinkhole during a charity bike ride in Philadelphia. The City of Philadelphia asserted that a release signed by appellant relieved it of liability. The trial court deemed the release to be invalid as against public policy. Commonwealth disagreed, concluding that in the context of a voluntary recreational activity, the release was enforceable. Appeal was allowed to review that determination. Mr. Valeri.
May it please the court. Good afternoon. Chief Justice Saylor, Associate Justices. My name is Leonard Valeri, and I represent the appellants, Anthony and Karen Degliomini. It's an honor to be here. There were two issues that were certified for review by this court. The first is whether the city can contractually immunize itself from the liability for breaching a mandatory public safety duty that has existed for decades, not only in the common law, but was codified in 1983 under the Tort Claims Act, and is also contained in what I will be arguing is the same as a statute in Pennsylvania's Home Rule Charter. The second issue certified for review that I would be discussing, but I don't even think that we get to it, is whether a party can be released from its prior negligence that existed and was committed well before the event was ever organized, well before the release was ever prepared, and well before the actual event ever took place in which the appellant was injured. I would submit that the city cannot do what it is doing for several reasons. First and foremost, it would lead to an absurd result. It is very clear that our legislature intended to waive immunity against the City of Philadelphia for defects in their roadways that cause serious injuries to the citizens of Philadelphia and other jurisdictions as well because of their negligent repairs or negligent maintenance. Why it would lead to an absurd result is I can give you an example. If Mr. Degliomini on May 17th, 2015, who paid his registrant fee and signed that release, was rounding that last turn on Patterson Avenue and was proceeding towards that sinkhole, and for example, Justice Doherty was deciding that day he was going to go to the Phillies game and he was going to ride his bike to the Phillies game, and he caught up with Mr. Degliomini. They struck a conversation and they're riding together, and the both of them on May 17, 2015 fall into that sinkhole, and they both sustain injuries and they both bring claims. Mr. Degliomini will be precluded from bringing his claim because of the release, but on the same day, under the same circumstances, with the same defect, with the same duty that the City of Philadelphia owed to Mr. Degliomini and Justice Doherty, Justice Doherty's claim would proceed because he didn't pay a registrant fee, and that would lead to an absurd result.
And he didn't sign a release, counsel.
He did not sign a release, but the city's duty in this case, Justice Wecht, and here's where our paths diverge with the city. The city's duty in this case is independent of the actual biking event. So regardless of the fact that Justice Doherty didn't sign a release and Mr. Degliomini did, because the city had a duty that is legislated by our assembly to repair and maintain their roadways, Mr. Degliomini should recover as well. The fact that a release was prepared in this case by the city directly contradicts the legislature's clear intent in 1983 when they did that study that was mentioned in the city's brief, and they came to a conclusion that they were not going to do away with or allow the city to do away with tort immunity. They were going to continue along the path of 120 years worth of common law negligence against the city for negligent repair and maintenance of the streets. And so
Mr. Valeri, I'm sorry. Go ahead.
Yes,
This
sir.
is Justice Barry. Go ahead and finish your answer.
Well, what I was going to finish by saying is, and then they codified it. Nowhere in the TCA, the Tort Claims Act, does the legislature allow for an out for the city to immunize itself with an exculpatory clause. Go ahead.
And what I was going to ask you is, it seems to me that your argument has stunningly sweeping implications. Your argument is that no entity clothed under the color of state law can sponsor any event which has any dangerousness to it, any risk to it, without assuming liability regardless of anything. So, you know, the city of Pittsburgh, where I live, or the city of Philadelphia, can't have a triathlon, and we've had that case. Can't have a bike race, can't have a charity run. I guess private entities could, because they could get the waiver. Can't have a golf tournament where somebody could get hit in the head, et cetera, et cetera, et cetera. Because your argument is that the legislature has, as a matter of policy, prohibited any municipality from waiving liability.
Well,
Is that right or wrong? Yeah.
I respectfully think you're wrong. I would say that I do not think that the decision in this case has wide sweeping effects. We will continue to go on and have the Susan G. Komen breast cancer walk every year. The events organizers are the ones that would be responsible in that instance. The city of Philadelphia would certainly be responsible for West River Drive. But for you to invalidate this release,
well, so Mr. Valeri, if I can follow up, if in the Susan P. Komen breast cancer walk on West River Drive, somebody sinks into a pothole, and the trial lawyer's position is that it should have been fixed, the city can no longer say, well, you signed a release. Correct or wrong?
Correct. The city cannot enter into the release in the first instance. Where I disagree with Your Honor is where you said that the legislature, as a policy consideration, allowed for this. No, the legislature enacted a statute which required the city to be liable for negligent repairs. Nowhere in the legislative intent, nowhere in the Tort Claims Act does the legislature indicate that the city could wipe away its immunity with an ad hoc contract. It just doesn't exist in the law. It has never existed in the law, and we will not find a case under Pennsylvania law that will relieve the city of ultimate responsibility, regardless of any reason.
So you're saying to me that this court, and you may be correct, I can't tell you off the top of my head, has never held that a governmental unit can sign a release and have it be good.
Not under these circumstances on a public street. That's the caveat, and that's I believe that I am correct. To do otherwise, Justice Baer, I believe respectfully would be legislating from the bench to allow the city of Philadelphia the opportunity to immunize itself when the legislature has told all of us folks you're not allowed to do it. And how do we know that? Because they carved out that immunity exception when back in 1983 they could have said, but we will grant you the opportunity to immunize yourself. What the legislature did do, Justice Baer, is they allowed for the city to limit their liability with indemnification agreements. So when you talk about catastrophic events, to me, the simple solution is to contact the city solicitor's office, get the contract person on board, and say, when ESM wants to do this race again next year, or when Susan Komen wants to do her walk next year, you have to have the event organizer through insurance, which is permitted under Pennsylvania law, indemnify the city of Philadelphia. That's really why we're here, because it wasn't done in this case.
They can buy insurance, I know. Let me ask one more question. Justice Todd wants this question, but just I got you. It's accurate that you've not pleaded gross negligence or recklessness, which we have held as a matter of public policy cannot be waived. Is that correct? This is a negligence-only case.
So it is, but here's the reason why in this particular circumstance, Justice Baer. I pled recklessness as to the private event organizer because Pennsylvania law acknowledges that claim. The Tort Claims Act does not acknowledge reckless conduct and still allow the exception waiver. So yes, we are talking about just a purely negligence claim against the city of Philadelphia. Believe me, if I could have alleged gross negligence or recklessness, I would have.
Thank you, Justice Todd.
Justice Todd here. Philadelphia, contractual party to the release or merely a third-party beneficiary of the release?
Justice Todd, I didn't hear the first part of your question because you cut out on me. I apologize.
No, that's all right. Can you hear me now?
Perfect.
My question was the city of Philadelphia a contractual party to the release or merely a third-party beneficiary of the release?
They were a third-party beneficiary of the release. Through discovery, it was determined, and I believe that there was testimony at the trial as well, that the release was prepared by ESM for ESM, and then they went to licenses and inspections to get the permit, and they added the city of Philadelphia as a beneficiary in that. It was not the city of Philadelphia's release, and it was not the city of Philadelphia that drafted the release. It normally comes when you see indemnification provisions. For some reason, there was no indemnification in this case. That's why we're here.
Is it a consequence in your argument that they were not a signatory to the release?
I mean, I argued that when we argued post-trial. I'm sorry. We argued motions in limine, and I said the city has no part of this. They have no dog in this fight. It's not their race. We're only talking to, and I tried to distance it, obviously, for my own strategic reasons, being that I did not want the city grouped in any way, shape, or form with the race itself, because I wanted to concentrate the lower court on what I believe to be the true issue in the case, which was the city always still has an obligation to maintain and repair their streets. Let's not even talk about this release, and especially since they were not a signer on the release, I don't even think they got the benefit of having that protection. But again, my argument actually is that the city cannot have a waiver where there's an exception to immunity and the legislature hasn't allowed on the law.
Could I probe that duty, counsel? Could I probe that duty for a moment? Justice Wecht, questioning you.
Yes, sir.
Is the question of whether the city can reasonably be charged with notice a question of law or a question of fact?
Well, I think it's always a question of law, and I think in this instance, it wasn't even. It can be a question of law. If the city had chosen to, the city could have filed a motion for summary judgment at the trial level to say that they were on no notice of the defect, and as a result of that, they should not be held liable. So it's a question of law.
The reason I'm asking that question is just so you understand where I'm trying to understand. Well, let me ask you this. As we try to assess the scope of the duty in a case like this, and we think about the law of torts, should we be thinking about the duties that might be ascribed to a massive municipality with the sixth biggest city in the country? I think Phoenix passed you up, right? You're sixth biggest. Anyways, whatever you are. My question is, what is the influence, if any, on the question of the scope of the duty of the fact that we're talking about a massive city with any number of potential road hazards, and whether your Department of Streets can be monitoring them?
Again, and that kind of coincides with what I believe Justice Baer's concern was, and there's a couple different responses. One, so what? We're a big city. You know what? We have a lot of taxes. We have a legislature that made a decision for city of the first class. The legislature made a decision to have that exception to immunity, and the legislature, our great legislature, decided to put a cap on damages, whether you like it or you don't like it. Those are the safeguards that the legislature decided to put in place. Now, as a justice in a state with the sixth biggest, well, we're still a great city no matter what we are. But regardless of that, your concern for the city of Philadelphia, although I'm sure genuine and founded, has been safeguarded by a couple different things. That cap on damages, and the legislature in the TCA told the city of Philadelphia they can get insurance of their own to cover their losses and damages. Now, yes, would that be a big premium? Of course it would. But on the other hand, we have survived all this time through our litigious society, and the city hasn't gone bankrupt, and we've been able to pay our bills, and we still move forward, and the city still repairs its streets. But I don't think that it should. I don't think that should be a driving concern for this court in terms of what your decision should be today. I think again you have to follow the legislature.
But again,
Counsel,
Yes,
this is
Justice Donahue.
Justice Donahue. Point of privilege first. Justice Baer, could you your microphone?
thank you.
I'm sort of getting back to a more preliminary point here, Counsel. What the Act does is allows for a municipality to be liable to the extent that a private property owner would be, i.e. someone without the immunity. How do you derive from that a limitation on the defenses that can then be raised by the municipality? You would agree with me that a private property owner could, of course, enter into a release or exculpatory agreement that we have here. What is it about the statute that deprives the municipality of doing the same thing? Or is it as simple as it's the extant duty that underlies the municipality's responsibilities in this case?
What was the last thing that you said? The what duty?
The existing duties.
Existing duty.
Yes.
Okay. So yes, Justice Donahue, now we're getting into what is the Arresto case to a certain extent. So in Arresto, and I understand where you're going with this.
Well, I'm anticipating an argument that's going to be made by your opposing counsel, and I'd like to hear your answer to that question.
So if you read the actual TCA itself, and I'll state it for the record, it says the damages would be recoverable under common law or statute, creating a cause of action if the injury were caused by a person not having available defense under Section 8541 or Section 8546, and this is, I think, the important part. The injury was caused by the negligent acts of a local agency or an employee thereof acting within the course and scope of his duties with respect to these categories, the streets exception. So I guess the question that you're saying is it's not fair for the city of Philadelphia that they can't immunize themselves when a private party can.
I don't know if it's fair or not. I'm just asking you, what is the answer to the question? Why can they not enter into the same type of exculpatory agreement that a private property owner might be able to?
Because the city of Philadelphia's obligation under the home charter and what the legislature thought that they would be protecting is public safety and human life. And it is a policy consideration that the legislature considered in enacting a statute while maintaining the streets exception that was the law for 120 years. A private party can do so with insurance. The city of Philadelphia is the only person that owns its streets. So the legislature made that decision that the city of Philadelphia streets are important enough that we do not want its citizens to injure themselves on. And if they do, we want recourse. And that's why, unlike a private party, who has the ability to get private insurance at a more reasonable rate. The city of Philadelphia, who takes in tax dollars but has to maintain all those streets, has to do so. Otherwise, we'll have mayhem. You folks, of course, are genuine in your concern about what will happen if you waive this, if you allow this release. Isn't it equally concerning that if we do not hold the city's feet to the maintenance of their roadways, what the city will become in terms of the roadways and the injuries that will occur with no recourse? And then what we'll have is a bunch of injured people that cannot have what they need to make their recovery.
Mr. Valeri.
Yes, Justice.
Mr.
No,
Valeri.
no, Justice Donahue finish.
Thank you. Let me be clear. I don't have a concern one way or another about the welfare of Philadelphia or any other city, to be honest with you. I'm trying to get an understanding of what the language in the statute means in terms of a limitation on the city's right to raise a defense that a private property owner would have available to it. And you mentioned insurance. That's a different issue. The question is, where does that limitation on defenses arise from?
What I think the legislature's language meant when it talked about the city's liability as opposed to a private person under the common law or statute was essentially this: the legislature made a determination that the city of Philadelphia would have to maintain its streets, and that's why we carved out that exception. And then the legislature, in their knowledge, in their wisdom, said, but you know what? There are going to be situations where a private actor is going to have a benefit that the city would not have because of this waiver, and that's not fair. And that's the Arresto case, Justice Donahue. In that case, a snowmobiler crashed into a tree on Commonwealth property, I believe in upstate Pennsylvania. And there were two acts, and this plays in exactly to the language of the TCA. And the two acts were the Recreation Act and it was the Sovereign Immunity Act. And the landowner in that case, which is the Commonwealth, which is a governmental agency, said, you can't sue me, snowmobiler, because I am immune under the Recreation Act, even though I am a public entity and not a private entity. And the Recreation Act applies to everybody that has recreational land where people can go on. And the plaintiff in that case said, oh, really? I am suing you under the sovereign immunity exception to the real estate, where your real estate was defective and that tree should have not been close to where the snowmobile road is. And this court, the Supreme Court said, we have to, as a matter of law, read both of the statutes in conjunction with each other. And they said, in this very specific instance, which is what you're concerned, what the legislature intended us to do and decipher out of that clause, 8542.1, is this: although there is an exception for the real estate against the Commonwealth in this case, because a private party would have immunity like the Commonwealth could, we will allow the Commonwealth to take advantage of what would be a private immunity. That's what it means. Those circumstances, Justice Donahue, though, are so very limited and so rare, it should not cause any hesitation in disallowing this release.
Okay, thank you.
Yes, ma'am.
Counsel, Justice Baer again.
Yes.
And I'm listening intently, you're arguing very well. What seems to me glaringly missing from your argument is in passing the real estate exception, streets exception, to the Tort Claims Act, the legislature never said this is non-waivable, there's absolute liability if you don't take care of your streets or the like. And again, it seems to me that there have been many cases in Pennsylvania held that have held that that there's no public policy against waiver. You're insisting you're not arguing, but looking at, and I pulled it up, at the language of the Tort Claims Act, I just don't see anything that indicates that this is non-waivable.
Well, Justice Barry, you have to go through the legislative history, and you have to review and read a statute as you're required to do. And if something's absent, it doesn't exist. You can't judicially imply into the Tort Claims Act that the legislature intended there to be a waiver without saying it, while in the same breath and understanding the legislative history which led to the codification of the Tort Claims Act, that we are going to make a conscious decision, even after reviewing our fiscal problems and how we want to address fiscal concerns into the future. We are going to continue to maintain that you do not have that waiver of immunity. I'm sorry, you do not have that right to immunity. There would be no good common sense reason, Justice Baer, for the legislature in that legislative session to have carved out the exception for the sole purpose of telling the city of Philadelphia, and here's the way around it. This doesn't make sense.
Well, again, there is a distinction in the law between trying to get around it for its own sake. The cases that say you can't waive a public duty, but this is factually distinguishable because this is a bike race. And what happened to your client is a tragedy, and we all empathize. But still, he did not have to participate. I mean, that was his choice.
He did not have to participate. But then again, Justice Baer, this is not a private recreational arena. These are the streets of Philadelphia.
Right.
That's
Let me ask you before I conclude, and you've argued it very well, and it was great food for thought. Under your argument, the fact that this is a conspicuous, appalling sinkhole is irrelevant. It could be a pothole, it could be a waiver in the asphalt, so long as the other conditions of the real estate exception are met, that the city had actual knowledge, sufficient time to fix it. Regardless of what the defect is, liability would occur under your theory. Am I right?
There's one thing about, yes, but there's one thing about that you said that I just want to point out. When you said a waiver in the asphalt, I don't think that is actionable. And we know that from the Scott case, which I think council is going to rely on, which is really no defect at all. And there was one case, I forget the name of it, forgive me, that is mentioned in the briefs, both briefs, where a bike tire got caught in a ridge in the ground.
Right.
Those are not defects, but otherwise I would say yes. I don't care if it's 26 feet wide and 6 feet deep, or it's a pothole. If it causes an injury and is something that under our law, as would be analyzed by a judge, person, and a jury, the defect is a defect.
Okay, thank you so much. I'm done.
Thank you. Thanks, Mr. Villarney.
Yep.
We'll hear from Ms. McNaughton on behalf of the Aplt.
Thank you, Your Honor. May it please the court, Jennifer McNaughton for the City of Philadelphia. Regarding the Tort Claims Act, I think the Degliominis fundamentally misunderstand what the exceptions to the Tort Claims Act do. The Tort Claims Act exceptions are not remedial. They don't guarantee a right of recovery. They're not like the Wrongful Death Act that this court considered in Valentino, and they're not like the probate code provision that the court considered in Dorsey v. Redmond. All they do is lift the bar of immunity under those specific exceptions. They simply allow the city to be sued. And in fact, the Act itself, Section 8542A1, specifies that it does not create a cause of action. It looks to existing common law and statutory causes of action. So if somebody is injured within the scope of one of those exceptions to immunity, and there's no existing cause of action out there, that person's out of luck. So there's no explicit requirement that the city needs to pay out in a suit under one of these exceptions. In fact, I think that's another misconception here. The cases like Gray that talk about the fact that the city's immunity is absolute and non-waivable, that doesn't apply in the reverse. Liability under the exceptions is not absolute and non-waivable. Absolute liability would be a fundamental sea change in the way that lawsuits under the duty to repair streets or any of these other exceptions have proceeded under the common law for decades, if not centuries. All that the General Assembly did was allow the city to be sued. That's what all that these exceptions do. And with a few caveats, like the fact that we can only be liable if a private defendant under similar circumstances would be liable. By and large, the General Assembly was content to let the existing rules of the common law or the statutory causes of action play out. And under those
Counsel, this is Justice Doherty. Share with me, what's your argument as to why the city should benefit from being a non-signatory to the Philly's exculpatory release?
Third-party beneficiaries have the right to enforce a contract. And
I understand that. Now, with regard to the home charter rule, which is the governing document for Philadelphia's municipality, that specifically in section 5.5-500 mandates that the city of Philadelphia shall maintain its streets. How is it? I guess the first question I have for you is, do you believe that imposes a public duty on the city to maintain its streets?
No, Your Honor, it does not.
Then share with me why the city attempted to fill that pothole 9 months prior to this accident.
We have an existing common law duty that has, as Mr. Valeri has pointed out, has existed for decades to repair our streets. And in fact, that is the duty that the Tort Claims Act exceptions recognized. So no, the Home Rule Charter did not create any duty of care. In fact, if that were the case, we would be seeing plaintiffs' lawyers in personal injury cases arguing that left and right. That's a very powerful statement to a jury. And yet, I've exhaustively surveyed the law of the Commonwealth. I've found not one case where any court has found that the Home Rule Charter or any similar document has created a duty of care. So,
it's fair to say, prior to the execution of this release, the city of Philadelphia was aware of a large pothole on Patterson Avenue.
Right.
And yet you want to enjoy the privilege of being excluded from liability based upon what? Your lack of knowledge, your knowledge that you only patched it up part way? I'm confused as to your logic with regard to common negligence.
Right. So first of all, I don't think it's in the record, and I don't think it's clear that the city was aware that the patch had failed. We were aware that the pothole was there. We tried to fix it, but I don't think there's any evidence that the city knew it had failed. But secondly, and more importantly, we know, regardless of whether we know of a specific pothole, we know it is impossible for us to guarantee that our city streets are going to be 100% safe for a mass bicycle ride like this, where you have 800, I think it was 800 riders, all crowded onto the same city street, all traveling at a fairly good rate of speed. And that is why these types of releases are so important, because we can't guarantee.
I apologize, but that causes me to pause. Mm-hmm. I understand the city cannot maintain each and every street, such as a side street, but Patterson Avenue is a main thoroughfare, not only in Philadelphia, but in South Philadelphia, for which was the traveling location of this bike race. So share with me, what, if anything, did the city do did they place a yellow horse or an orange cone, knowing that it was, what was it, a 4-foot by 1-foot pothole, the main thoroughfare along Patterson Avenue, which is the entrance to both Walt Whitman Bridge, I-76 and I-95?
The city, there was a dispute during trial as to whether it was the city's responsibility or the organizer's responsibility to mark road hazards. But no, the city did not go out there and mark every single pothole and sinkhole. There were warnings given to the riders before the race, both on the internet registration form and announcements made at the time of the ride, telling people, watch out for potholes, watch out for sinkholes, watch out, or excuse me, they didn't say sinkholes specifically, but watch for potholes. Trolley tracks. We knew there were trolley tracks that the riders would have to cross over. And these conditions were presented to Mr. Degliomini when he agreed to the release in this case. So it wasn't that
finish your answer.
So he wasn't misled into believing that the road conditions would be perfect. On the contrary, he testified that from the very start, he noticed we had potholes. Unfortunately, that's the reality of the city streets in an area that gets freeze and thaw cycles and a lot of heavy truck traffic like on Patterson Avenue that really eats up the streets. We knew we couldn't provide perfectly safe streets, and that's why releases like this are so important, because if somebody wants to participate in a ride like this, and people do, it's a fun event, but they have to be willing to assume the risk that goes along with that.
Ms. McNaughton, it's Justice Todd. How do you respond to the public policy argument that the General Assembly would not have envisioned or endorsed the city being allowed to release itself from liability in this situation?
Well, first of all, there's nothing in the Tort Claims Act that says we can't do that. And in fact, the provision of the Tort Claims Act that says that we're supposed to be put on an equal footing to a private defendant once the door is opened for a lawsuit. At the time that the Tort Claims Act was written, a lot of these classic cases involving exculpatory releases date from around that time, the 1970s and 80s. So it was well known at that time that exculpatory releases exist, and yet the General Assembly chose not to specifically go the step further and prohibit us from engaging in that kind of a defense. I would also just harken back to my earlier argument that merely the fact of providing an exception to immunity, which is the overarching policy of this act, it is to limit the city's liability and limit the harm to the public fisc and to taxpayer dollars caused by tort lawsuits. In providing these limited exceptions, there's nothing in the words or the history of the act that says our liability was supposed to be absolute.
Counsel, could I jump in on that and follow up on your answer to Justice Todd? Suppose you prevail. What's the principal difference between the city of Philadelphia going back to the drawing board and saying, we won that one. Now we're going to require everybody who rides a bicycle in the city of Philadelphia to register it, and as a condition of registering it, sign a waiver, much like Mr. Degliomini had to do here, or say everybody who's going to park in the city of Philadelphia has to register for parking and sign a similar waiver. I don't see the principal difference. Do you see one?
Well, yes, Your Honor. There's a well-recognized exception to exculpatory waivers that affect essential services. So the everyday commuter's use of the road for commuting to work or parking their car, as Your Honor just described, that type of release would not be enforceable because it affects an essential service. So there's an element that of the general population not having a choice in that instance. Whereas in this case, the release was limited to one event. It was a recreational event with some inherent degree of risk. When you've got this many people traveling along in a pack, it's just inevitable. You're going to have vision being obstructed and some inherent risk of injury. These types of sporting events, it's the context of this release. So no, this release doesn't.
Ms. McNaughton, I'm sorry.
Counsel, Justice
go ahead.
Again.
Yeah, go ahead.
You indicated that regarding essential services, is it your position that the Department of Streets is not an essential service for the city of Philadelphia?
The Department of Streets provides, it assists the city in providing the essential service of roads.
When you say assist, it's an arm of the executive branch, correct?
I believe so, yes.
Correct. So I guess the question is very basic, yes or no. Are you indicating that the street departments of Philadelphia is not an essential service?
Not at all. But that's not the scope of the release here. It wasn't asked for in the scope of an essential service. It was asked for in the scope of just I
have one other question, if I may.
Sure.
In your brief, you cite Taylor versus Camelback, which in fact cites Leidy versus Deserter, a 1977 Supreme Court case, in which this court has ruled that releases are contrary to public policies in 4 situations. One happens to be where a party is charged with the duty of public service. I believe you previously indicated that the city has, pursuant to the home charter rule, has a duty of public service of maintaining its streets. If that is so, then why in your brief why would you disagree with the Leidy finding from this court that in fact that the release is contrary to the public policy?
Because in this instance, the release was not asked for in the context of an essential service. It was asked for in the context of a recreational activity. In that sense, the fact that we have streets to offer, that is how we can host an event like that. So this wasn't people going to work or any other essential travel. This was a sporting event. So in that context, we are acting the same as, say, if this event were held on a golf course or some other private property that has a lot of roads. That owner of the golf course would be perfectly free to ask for an exculpatory release like this one.
That's the difference between private and public ownership. Thank you.
Ms. McNaughton, Justice Baer, I want to take you back, if I might, to a hypo that was offered by your opposing counsel. Assume for a second that assuming streets are not blocked off, and as this race is ongoing and this plaintiff is riding, Justice Doherty's on his bicycle beside him, but a sign no release is commuting to the Phillies game by bicycle, and he hits the sinkhole and hits. Assuming again that the city has actual knowledge in accordance with the Tort Claims Act, is there anything that precludes him from suing?
No, Your Honor, he hasn't signed a release.
So this case comes down to the release. If, again, to use another hypo, as I try to get my mind around all of this, the Susan B. Coleman is going down, I think it's West Deer Avenue. I'm not from Philly. And somebody falls into a pothole. If they've signed a release, does that eliminate liability? Waive liability?
Right. In that context, it would, because it's one of these special events. It's not an essential.
And in the same context, I'm sorry, I didn't mean to interrupt you, but I'm thinking ahead. Same context, if they've signed no release, is there potential liability?
Yes.
All right. So the whole case comes down to whether the legislature and the Tort Claims Act prohibits, as a matter of law, a waiver.
That's correct.
Okay, thank you.
Yeah,
Could I follow up?
Justice Donahue.
To Justice Doherty and me, you had talked about essential services. I just inquiry on that, if I may.
Sure.
You seem to rely on a distinction between essential and non-essential. So you want courts such as ours in reviewing liability waivers like this to be in a position to decide whether the rider or driver, if it's a car, is commuting for work versus just getting some exercise. That the law of torts and liability exposure under it is going to turn upon some societal valuation of the essentialness or non-essentiality of the activity. I'm not sure how courts are going to wade into deciding whether this activity is essential or the other one is not. Can you offer us a guidepost for that?
Sure. And Your Honor, I apologize if I was unclear, but essential services, as I read the case law, and granted, I have not found any cases specifically dealing with roads, but it encompasses ordinary use of that service. So the most cases, the most number of cases in this arena tend to be these old railroad cases. A common carrier is considered an essential service. And in those cases, I've never seen a court distinguish between somebody taking a ride on a train to go to work versus a ride on the train to go to the countryside for a vacation. Those are ordinary uses of the essential service. And I think those would be encompassed within the bar on enforcing exculpatory clauses in that context. Where this case falls outside of that is it's a special event. It's not an ordinary use of the road. It's not every day. And this was a big event that required a permit. 800 people riding in this event. So it was not your everyday ride for exercise.
Justice Donahue has a question, and then I think we're going to try to.
I thought maybe I was muted.
Sure.
Let me just talk to you about a real problem that I'm having with your argument. I have a hard time parsing this duty that the city has, which it's a common law duty. We'll get away from the statutory basis of it, but how does the city get to decide situationally when it has this overarching duty? This whole notion of comparing the city to, Camelback Ski Resort, a private entity. What happens at Camelback Ski Resort is that people ski there. That's what they do. Or they, ride snowmobiles or something of that nature. And that's the purpose of that property, and that's what the landowner does with it. What we're talking about here is something very different. The city of Philadelphia decided to sponsor this event that had 800 people on the streets that it has an overarching duty to maintain. How is it that the city can then step back and say, okay, here we don't have a duty, because that's what an exculpatory clause does. It eliminates the duty, but in other circumstances we do. I just have a very difficult time parsing a duty in that fashion.
Right. Well, Your Honor, the fact is that we were acting like a private landowner in this instance because we were offering our land for really, it was a special event. But you aren't a private landowner, and therein is the rub in this. Under all circumstances, the duty exists to maintain that roadway. Period. I mean, and that gets down to parsing again. Well, here it's like we're a private entity, but overarching all of this is that we aren't, and we have a specific waiver of immunity in certain circumstances, but not here, where there is this overarching duty to maintain the roadways. I just, from a theoretical standpoint, I'm having a very difficult time grasping how you parse this as finely as you're doing. Well, I would direct Your Honor to the discussion, I believe, in the Chepkovich opinion, talking about why releases for recreational activities are generally not a problem under public policy. It's because there's no compulsion. And that's one of the key distinctions here. That this is a recreational event. It has inherent risk of injury. And Mr. Degliomini was not under any kind of pressure to sign this release. He could have walked away. Whereas your ordinary use of the roads, people need roads. That's why they're essential. So there is a degree of compulsion in that circumstance. And that's, again, an ordinary use of the roads that's outside, it's every day. Whereas the release here was strictly limited to just the people, the event, the time and place, and freely agreed to by the parties. In fact, that's how events like this can happen. We understand that we are not going to be perfect. Our roads are not going to be perfect. But if people want to engage in these activities like marathons and charity rides and bike races on our streets, they have to accept the fact that we simply cannot repair every single pothole with the hundreds of miles of streets that we're responsible for.
But see, that same argument could be made by you about anyone who rides a bicycle down the street. We can't possibly be held responsible for maintaining all of these hundreds of miles of roadways. The duty is just there in the atmosphere, so to speak. The distinction that you're making is just one that seems to go against the notion of this overarching duty that the city has, which you're eliminating in this circumstance. Much of what you talked about today goes to, he should have seen the pothole, or he should have seen the sinkhole, or thing. That's certainly a defense. Comparative negligence or something like that is certainly a defense to such a case. But this elimination of the duty in this situation is just something that seems to rub against the exception to the immunity provision and the notion that this individual is actually in a different situation than anybody who is a member of the public is.
Well, I would
Probably not going to agree on this.
No, 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 and I especially disagree with the notion that the Tort Claims Act imposes a duty. I mean, by its very language,
It does not.
It does not. It does not.
Well, you already have a duty, though. That much we've
Yes.
established through Justice Doherty's astute questioning. So, I mean, you know, the duty is a public duty. So,
Sure. Well, it's
your argument.
analogous to the duty that a business owes to its invitees. That is a pre-existing duty. And under the proper circumstances, that can be waived through a release like this. So in the context of this ride, it's a very limited waiver. And it's necessary. There's a competing public policy to allow these types of sporting events to go forward. The city isn't a business making a tremendous profit off of this. We're not Camelback Ski Resort. We're simply offering up our land for these events that people want to attend, and they're fun. They're good for the local economy. They're good for the people participating in them. But
it's not a waiver, counsel. It's not a waiver. I mean, what we're talking about technically, realistically, is an elimination of your duty. I mean, that's the problem. That's the problem with the context of an exculpatory clause like this.
Mm-hmm.
I mean, what it is under the law is an elimination of the duty. And in the context of a public municipality such as this, I find that hard to reconcile. But as I said, I mean,
Okay,
I understand your argument, and you've presented it well. I mean, and it certainly has legs. I mean, it's just you know, it's really a question of meshing it within the framework of eliminations of duties and public entities.
right. But I would just briefly respond, Your Honor. There are two competing arguments about or interpretations of the Tort Claims Act that have been presented to this court. And on the one hand, we are pointing to the explicit language in the act that says the act's overall purpose is to protect the city from liability. That's its goal. And the city cannot be held liable unless a private defendant in similar circumstances could be held liable. That's explicit in the language of the act. And on the reverse side, the Degliominis are arguing for this implied duty or an implied policy against an exculpatory release like this one that isn't explicit in the text of the act. So under basic principles of statutory interpretation, there's simply no policy in there to be read in favor of barring the city from executing a release like this. The Tort Claims Act just doesn't do it. Where the language is explicit in a statute, we can't ignore it in favor of an implied or a supposed policy goal.
Thank you. Thanks to both counsel. I will
Chief
conclude
Justice.
argument in, what's that?
Justice Todd here. I just wanted to compliment both attorneys, Ms. McNaughton and Mr. Villari. Those were both outstanding arguments.
Yeah, thank you. They were excellent.
Thank you very much.
5 minutes. Pause.
The next matter is in Commonwealth of Pennsylvania versus Joseph Bernard Fitzpatrick III. Representing Mr. Fitzpatrick is Mr. Jules Epstein. Representing the Commonwealth is Mr. Tim Barker.
Good afternoon. Appellant was charged with murdering his wife. At trial over appellant's objection, the Commonwealth introduced into evidence a note written by the victim, which suggested that should anything happen to her, appellant would be responsible. On appeal, the Superior Court held that the note was admissible under the state of mind exception to the hearsay rule. Appellant is challenging that determination. Mr. Epstein.
Thank you, Mr. Chief Justice, and may it please the court. If anything happens to me, Joe, that is a paradigmatic statement of belief. If anything happens to me, the person who is responsible is Joe Fitzpatrick. And that's precisely how that statement was admitted at this trial. It's how it was argued by the Commonwealth in opening statement. It's how it was argued in closing argument. And under this court's decisional law, federal law on which our Rule 8033 was modeled, under the explicit language of 8033, and as confirmed by any evidence treatise we would look at, be it national or Pennsylvania, that makes it inadmissible hearsay. How did this go wrong? The Superior Court made 3 errors. It completely disregarded this court's precedent. It created a legal fiction by saying this wasn't offered for its truth. It was offered for some other reason, never mentioning how it was used in the opening and closing.
Mr.
Yes.
Justice Todd here. Maybe I am thinking that all those years of treatises are wrong. I don't know. But it seems to me that there is indeed a good argument to be made that this statement was not hearsay, which means we don't get to the exception, the state of mind exception to the hearsay rule. Now, hear me out. If it, in fact, was not offered for the truth of the matter asserted, if it was not offered to say, Joe killed me, I'm predicting in advance that Joe will kill me, but rather evidence that I, the wife, am afraid, I am in fear, I have concerns, which could be admissible. Now, I know what you're going to say. You're going to say, but the opening and closing arguments foreclose that possibility. You know, they aren't evidence. And what is more important to me is, how did the judge instruct the jury? Was there a limiting instruction on the use of this evidence?
There was no...
Sorry.
First of all, good afternoon, Justice Todd. There was no limiting instruction. The pre-trial hearing judge, who is different from the trial judge, ruled that it was admissible as hearsay. And although you are correct in the sense that no openings and closings are not evidence, in May of this year, this court, in a case called Commonwealth versus Coleman, said that when when assertions are introduced and there is no limiting instruction, we treat it that they were used for the truth. So we have Commonwealth used for the truth, no one telling the jury you can't use it that way. And we have your decisional law saying we must assume it was used that way unless the jury is specifically told otherwise. And if I may add one other point, there are 3 critical precedents from this court. Actually, I'm going to add a 4th to that later. But the 3rd in a string of cases is the Moore, M-O-O-R-E case. And in Moore, the precise same situation was presented, and this court emphasized that the error occurred in part because it was argued for its truth in closing. I hope that answered your question.
Thank you.
Counsel, Justice Doherty, I have a question. At what point did the Commonwealth introduce this? Was this in its case in chief, or was this in rebuttal after the defendant testified?
Case in chief. And again, mentioned in the opening. Now, if I may, I said that there were 3 errors in the Superior Court. There is a fundamental error in the Commonwealth's position. In a 63-page brief they filed with this court, they never once acknowledge, oh, that's how we argued it. They go off on the position that Justice Todd was adverting to, which is, well, there might have been a non-truth purpose, and let me explain what it is. But that's the trial as they might have imagined it, not the trial as it was. And that also presumes something, and Justice Todd, going back to your point, when I said there were 3 main cases from this court, they are named Auker, A-U-K-E-R, Laich, L-A-I-C-H, and Moore. And in Auker, this court said, and the only members of the current court, and were now Chief Justice Saylor and Justice Baer, that, I'm sorry, they weren't on Auker, please forgive me. But on Auker, this court said, the state of mind of a victim is rarely, if ever, relevant, and not relevant in a homicide. The example was given maybe in a kidnapping, because it would prove the victim would be less likely to go with that person. So we have a relevance problem under the not for the truth purpose, if that had been how it was used. But it wasn't.
Mr. Epstein, and I frankly think I'm probably helping you. Assume for a second that they don't put this in the case in chief. Your client's defense is we were all just a wonderfully happy family, and this is impossible. Couldn't they put it in rebuttal with a limiting instruction to show that they were not a happy family?
They might be able to. And so I agree with you that it would at least be confronting an issue in the case. Whether they are a happy family is a relevance issue, but assuming it is, there would be arguable relevance if it was a limiting instruction. But even then, Justice Baer.
Well, let me interrupt you. Assume,
Yes,
I'm going to change the hypo for you. His defense is she was absolutely never afraid of me. She trusted me implicitly. Everything was great. Now, that, I think, eliminates the relevance question, I would think. Now, does it get in rebuttal?
Maybe subject to a trial judge's Rule 403 assessment, but maybe. And again, with a limiting instruction. So,
all right, fair enough. I'm sorry.
Mr. Epstein, if I
No,
may-
go ahead. I didn't mean to interrupt you. Go ahead.
I didn't know you were done. I apologize, Justice. Go ahead. But Justice, Mr. Epstein, Justice Doherty again.
Yes, sir.
Following Justice Baer's comment, you're requesting that this court vacate and remand back for a new trial.
correct.
Assuming under your premise that this is a plain hearsay statement introduced in its case in chief, which is objectionable. Following the logic of Justice Baer, if the Commonwealth in a new case waited and introduced this statement as rebuttal testimony, should the defendant take the stand and again argue that it was an accident, it would be admissible pursuant to the case law which you cited, yes?
Well, maybe, and please bear with me. I am truly trying to answer your question, but there is explicit language in the Auker case that says in a murder case, and maybe that has to be revisited, but currently this court's precedent says in a murder case, victim's state of mind is irrelevant. But assuming it were relevant, maybe, and maybe with a limiting instruction, and then the defense would have to decide, do we testify? Do all sorts of things happen? Fair game in a different context.
But permit me, let me challenge you on the Auker case. I read that case as to the statements regarding the state of mind was inadmissible as to the murder because it was relevant to the kidnapping charge.
Agreed.
If this statement, as a hearsay statement, is relevant to negate the defense, then Alker is distinguishable and it would come in, correct, legally?
If you are correct that Alker is a qualified statement of law, not an express one, that's fine. I must admit, when I read it and made notes for today, it seemed to be absolute. But I have no problem as thinking as a logical person that if someone said, she loved me, she would never speak badly of me, we were great like this, that might be appropriate. And I get that. Again, though, respectfully, that's not this case. And one of the problems, if I may, Justice Dougherty, and we explain this at length in the brief, is that the lower courts, in particular the Superior Court in this case, but in lots of cases, don't understand the two senses of the words state of mind. There's 8033 state of mind for the truth of the matter asserted. And there's 8033, there's state of mind, what we call mental output, that there's some significance that this lady is saying it, whether it's true or not in the world. She thinks that, and that has its own significance. I will say to you that the Superior Court was so confused in this case that in one paragraph they said, therefore, this is admissible under 8033, and you ready for the second half of the sentence? Not for its truth. They don't get it. You are getting it because you're saying different uses completely. And I'm willing to say to you, if you are right that Alker is not as absolute as I read it, that's fine, because that makes logical sense. And then the only issue in any of those is Rule 403, because there's always a balancing of what's the risk of jury overuse or misuse. I hope I answered your question.
Absolutely. Thank you very much.
Mr. Epstein, it's Justice Todd again.
Yes.
Stepping beyond the issue we've been discussing of hearsay or exception to hearsay, the Superior Court also, interestingly, said that if the admission of the wife's statement was error, it was harmless error due to the overwhelming other evidence of guilt. Now, I haven't combed the entire record yet, but from the briefs and what I have read thus far, I'm not sure what the court would be referring to there.
So two things, if I may. They actually didn't say that, Justice Todd, because they found the admission of this proper. They were addressing an other piece of evidence, an email the victim had written, and said, and they found that error and said, but that's harmless.
Yeah, I'm not sure about that. That was a more explicit statement.
Right. But going to the, if you will, the merits of harmless error, and we discussed this at length at, I think it's pages 8, 9, and 10 of the reply brief, just very briefly. The trial judge actually granted a judgment of acquittal after the jury verdict because the trial judge believed the case was about this thin. Number two, Mr. Fitzpatrick testified, and under Commonwealth versus Story, which is the standard in Pennsylvania for harmless error, that talks about overwhelming and uncontradicted. And number three, if I may, and there are more points laid out in our brief, the medical examiner was themselves equivocal and said this also, the injuries could have been consistent with accident. So there was a lot of play in this case. This was not a slam dunk case. And again, a respected Pennsylvania jurist thought it was so thin that it was legally insufficient with the email and with the day planner notes.
Well, I will revisit this question with the Commonwealth.
I don't know.
Mr. Epstein, before Justice Beer, just
Yes, sir.
only because we do not have rebuttal. Justice Todd sort of reminded me. The Superior Court, I think, held that the day planner note got in, but the email did not get in because 8033 has this exclusion to admissibility, statement of memory or belief to prove the fact remembered or believed. Any comment on that?
The polite comment is respectfully, they don't get it. Okay, and here's why. Because they are both statements of, well, the email was a statement of memory averring something that had happened a night or two before. The day planner is a statement of belief. They called one a statement of memory, but the other, they ignored it's a statement of belief, and again, then created the legal fiction that it wasn't offered for the truth. So 8033 doesn't matter because, again, they ignored the Commonwealth's explicit use. And of course, they wrote their opinion before this court handed down the Coleman case, which said if it looks like an assertion, if it smells like an assertion, the jury's going to treat it like an assertion, and it is hearsay.
Thank you.
Thank you. Mr. Epstein, we'll hear from the Commonwealth.
Thank you, Chief Taylor. May it please I'm Tim Barker. I am presenting the argument today on behalf of the York County District Attorney's Office. Basically, in this matter, the the pretrial motion court did admit the note that did say, if something happens to me, Joe, under 8033. It did admit it under the state of mind hearsay exception. However, at that hearing, and as the Commonwealth had proffered and put forth, it was introducing that note as well as when it sought to introduce the email, due to the fact that already a key component to this case were the statements that the defendant made asserting that they had a happy relationship, and at the time of Anne Marie Fitzpatrick's death, that they were actually celebrating their wedding anniversary. And it was on that basis to refute and rebut the claims of the happy marriage that then led to an accidental death. That was the claim by the defendant, that the Commonwealth sought admission of the note. So that was always the claim with regards to the note, that it came in because the state of mind of Anne Marie Fitzpatrick regarding the nature of the relationship, their happiness, the state of their marriage, and to rebut the claim of accident, the very claims made by the defendant, beginning to Trooper Kaufman and individuals at the scene. That is why this was relevant and why this was a statement that related to state of mind.
But you want to have it both ways. If I can jump in, counsel, you want to have it both ways. And I guess we can't fault you because that's the Superior Court's doing here. They took something that was offered for its truth and said, you know what? It was offered for its truth, but it was also offered not for its truth, and it could have come in under impeachment or course of conduct or something else. You have to pick a horse and ride on it, and the horse you rode at the trial was for its truth. It seems to me highly problematic to come in after the fact on appeal and say, you know what, actually, it was a non-hearsay purpose.
Particularly, counsel, when there was no limiting instruction.
Yeah.
Well, we want to start off with...
And counsel, Justice Bear, and I guess we're asking you a compound question, but I'm in agreement with both of my colleagues that you offered it for the truth of the matter assertion. There was no limiting instruction. And it seems to me procedurally, you can't put it in your case in chief. You have to wait until they raise the defense of happy marriage, happy relationship, or the like, and then it comes in rebuttal. You prejudice them because you don't know when you're putting your case in what the defense is going to be.
Well,
So for all of those reasons, if you can sort them out,
sure.
we collectively aren't buying it. So you have a mountain to climb.
That's my pleasure. I'm ready to climb the mountain. We'll start first of all with the nature of the statement itself. If we remember that statement, well, I want to go back to one moment before that. The biggest problem that we have here with the state of the law, if you recall, when we went and raised the motion in limine, we cited to precedent. And there has been a blurring of the precedent that has been cited to by this court as well as by the Superior Court regarding what encompasses state of mind under the 8033 exception. And when this was argued, actually, there were two recent Superior Court cases, one of them in Bonk and Commonwealth versus Leicester, that were cited to, and that this fell within the scope of. And I just want to say that for historical context as to how the litigation of this transpired and took place. The comment in and of itself, the truth that was being sought to be introduced, and this is where the state of mind blur happens, it was that she was fearful. Anne-Marie Fitzpatrick was fearful of her husband. It was not that Joe was going to kill her.
But the problem, excuse me, the problem with that is, and I can buy that, as I told Mr. Epstein, to a point, but that isn't how the evidence came in. That isn't how the opening and closing arguments were made, and that isn't how the judge instructed the jury. If you can get me over those hurdles, I'm with you.
Sure. Well, it goes back again that if you're saying that that is what the truth of the matter asserted is the fearful condition, then it did come in for the truth of the matter asserted. And that's the problem when you have an equivocal statement like this that has two different meanings of what the truth comports, and where our law has had a difficulty in differentiating between from which prong it comes in. We would agree.
Barker, there's nothing equivocal about that. That's an accusation from the grave. If something happens to me, my husband did it. That's the most prejudicial kind of evidence you can get. And you're introducing that to the jury to prove that he killed his wife.
Well, we did introduce it to go ahead and support our claim of murder of the first degree, but in the context of, and this was how it was presented during the
equivocal. It said, if something happens to me, I want you to know it's my husband that did it.
Well, the reason why
examine her, she's dead.
Well, that's correct. That is correct. The reason why, and we were asserting, and the reason why I put it in that tone and that light is because what the ultimate truth aspect that was being pursued with it was the condition of fear and the condition of lack of happiness. Now, the problem is that has been interpreted from time to time as falling squarely under 8033, which does not have the same limit as non-hearsay. And that, unfortunately, is what we keep falling back into the trap and the vortex of 8033. And clarity would definitively help. Chief Justice Saylor, I know you've stated that on multiple occasions with regards to how clarity would help, especially in your opinion in Commonwealth versus Stallworth. And the aspect for which this was argued, and I know that there was a portion in the reply brief by the defense that had referenced when the prosecutor in closing stated that the voice of Anne-Marie is telling you something to the effect of the voice of Anne-Marie is telling you. That was in response to the defense closing when the defense in their closing argument argued the voice of Anne-Marie Fitzpatrick is telling you that Joe is an innocent man, and then immediately pushed play on the recording that they had that the defense introduced of her leaving a message on the answering machine tape to Joe Fitzpatrick's mother, to the defendant's mother that evening after the time period in which she wrote the note.
Counsel, Justice Doherty, I apologize. Can you share with me, because I'm getting confused. Are you indicating that the Commonwealth strategy of introducing that statement in the case in chief, the gatekeeping question, are you submitting that as a statement of emotion or a statement of fact or belief? Meaning, did you introduce it in your case in chief to say wife was fearful, or are you saying wife believed Joe would do it?
It was for statement of emotion. And actually, in the motion in limine, I believe that the terms that they used was to rebut, and it was on pages 95 through 97, as well as was in our memorandum of law.
Okay, I got that. Counselor, let's look at this legally. So you've introduced it for a motion, yet there's a plethora of case law that indicates the victim's state of mind is not admissible when we're dealing with murder one. It's the defendant's state of mind. With that knowledge, share with me what the strategy was to introduce a statement in the case in chief which decisional law rejects.
Yes. Well, we would start off with, and we'll cite instead to Commonwealth versus Stallworth, to the Chief Justice's concurring opinion in Stallworth, where it's cited to the Brown decision, and mention that in the normal murder case, that would be absolutely correct, that the victim's state of mind is not at issue. Leish clearly held that, as well as Thornton and other cases. Walker had mentioned that. However, the clarifying aspect, as well as the Chief Justice noted in the Brown decision, and it was explained thoroughly in the footnotes, has to do with when there are also claims of accident, claims of suicide, matters in which the victim's mind is now, her state of mind is now at issue. And in this case, the defendant from the very beginning, and the only reason why this was investigated as a homicide was because her coworkers found that note and the original email. There wasn't even going to be an autopsy performed in this matter by the coroner's office because the defendant asserted this was an accident. And so from the very beginning, and asserted from the very beginning, we had a happy marriage. We were celebrating our anniversary. And so that would be the exception based upon the claim of the defendant from the very beginning, and that the ultimate dispute was involving whether this was an accidental death and the victim's state of mind was absolutely 100% relevant to those concerns of happiness, emotion, state of mind, and accident.
So which of the menu options that the Superior Court gave you after the fact are you taking? Are you taking offered for its truth? Or are you saying not offered for its truth? Since according to you and according to the Superior Court, you seem to be able post hoc to just pick whichever horse you want to say you rode.
We're not. Well, with all due respect, Justice Weck, we're not doing some post hoc. I'm sticking to what originally was asserted in the motion in limine. And under the case law, under 8033, for the existing emotional state, it was offered for that. The existing emotional states were that regarding the happiness and fearfulness, I should say lack of happiness, the fearfulness with regards to her marriage with Joseph Fitzpatrick. That was the original offer. That was how it was introduced and how it was argued through. The fact that it has an overlap, which we completely agree with non-hearsay admission, is the problematic part of the state of mind introduction.
Counsel Justice Baird, did the trial court give a limiting instruction consistent with the way the district attorney trying the case saw that evidence?
No, there were no instructions regarding the.
So why isn't it reasonable? This is a murder case. Why isn't it reasonable to believe that the jury did not understand your nuance? The jury took it, as the Chief Justice said to you, as proof positive that he killed her based upon her state of mind, and therefore it requires a new trial.
Well, that's a two-pronged question for us, because the new trial component, we of course would go back to. I know, Justice Todd, you said you want us to answer questions at a certain point regarding the nature of all the evidence in the case. But concerning the initial prong, the limiting instruction, look, I mean, I'm in all candor to the court, limiting instruction for how to interpret multiple types of evidence, testimonial evidence, and different admitted evidence, can go ahead and definitely help. We will not shy away from that to make sure that the jury has laser focus. We presume that they would and not use it for any other purpose. The only thing that we can say is when you look at the arguments of counsel, and if the jurors were respecting the arguments of counsel, including the defendant's argument, which extensively went through Anne Marie Fitzpatrick's state of mind to establish that Joseph Fitzpatrick was innocent, based upon how she spoke to his mother and viewed their meeting together that evening for their anniversary celebration, then we're confident that they would have gone ahead and not let their minds run wild with that evidence. That would have focused away. I understand it's not as secure as a jury instruction. I'm not.
And apropos with Justice Todd, I'm sorry, Justice Todd.
I was going to move on to another subject. So if this is on hearsay, please go ahead.
This is on the same subject. Isn't Coleman dispositive of this case? Doesn't Coleman demand reversal in this case? There was no limiting instruction.
I apologize, Justice Donahue.
There was no limiting instruction. Doesn't Coleman demand reversal in this case?
We would argue no, because that reversal was decided upon the facts, which, quite frankly, those facts were relatively egregious. That much hearsay, the nature of the hearsay, how it had come into play, that there was no limiting instruction that was given, and quite frankly, the theory regarding the admissibility up front. Again, we're being in all candor. When reading the Coleman facts, they were problematic across the board.
So I'm so confused by that, because about 3 minutes ago, you argued that but for this and another email, the defendant wouldn't have been prosecuted. So, I mean, how much more egregious can the hearsay be in this context? He would not have been prosecuted but for these pieces of evidence.
I didn't say would not have been prosecuted. There would have been no autopsy. There would have been no investigation. If the prosecution happened because of all the other evidence. It was all the other evidence that led to that. But if there's no autopsy, by its very nature, there can be no investigation. There's no gathering of evidence. So, I mean, they were key at that moment in time for going forward, because if that wasn't turned over, there would have been no autopsy. There would have been nothing further. That was what I meant by that comment. I did not mean that to suggest, though, that by any stretch of the imagination that those were the strengths of the case. They, quite frankly, were not the strengths of the case. And and I know that was, Justice Todd, something that you wanted to ask about.
Well, yeah, I specifically, Mr. Barker, wanted you to address the Superior Court's analysis on harmless error resulted in their statement that there was, in light of, it was harmless if there was an error, in light of the overwhelming other evidence of guilt. And that's what I'd like to hear from you on. What was that overwhelming other evidence of guilt?
Sure. And I will try to keep it brief and paraphrased. We did, one thing I would refer to up front as I go ahead and say this, in our concise statement of the case where we lay out all the different facts, you'll notice there are two items not mentioned. We did not mention the email and we did not mention the note. And the reason why is because it showed and demonstrated how overwhelming the evidence was without those items. Quite frankly, the strongest aspects of the evidence will begin with proximity. The defendant, by his own admission, had actual physical contact with the victim at the time of her death. So we start with opportunity and proximity. Second, when we talk about the physical evidence in the case, the defendant gave multiple versions of events, including on how the accident occurred. When the accident was attempted to be reconstructed by Corporal Andrew Thierwechter, it was impossible to replicate the tire marks that were on the grass, utilizing the statements made by the defendant. It could not be replicated. In addition to, you could not replicate the body movements utilizing the exemplar dummies that were used in the case when they were putting the ATV over in the water. They couldn't even replicate the movement of the ATV. And that those experiments were also supported by Dr. Jacob Fisher, who was also an expert in biomechanics, who supported the work of Corporal Andrew Thierwechter. We had the motive evidence, the affair with Jennifer George, which had taken place over a period of weeks, and she basically ended that affair. And the defendant tried to keep that rekindled, including, and here was the biggest piece of information on June 6th. It wasn't the note from Anne Marie Fitzpatrick. The biggest information is he sends a message to Jennifer George saying, you may not need to move into that new house, or you may not need to buy that new house after all. Sends that in the afternoon, and then sends the words to, you are my sunshine, along with that. That was in a whole flurry of messages that were occurring that day between not only the defendant trying to win back Jennifer George, who he's having the affair with, but also receiving from Anne Marie Fitzpatrick trying to rekindle and repair the marriage as well, conflicting messages from her to the defendant. We had additional motive evidence regarding the insurance policy. You know, Anne Marie Fitzpatrick worked for an insurance company, and yet he's doing a Google search on insurance payments during the contested period. He had over $1.7 million of life insurance taken out against her. So then he also threw her cell phone in the other yard, had basically not told the truth about what he did with that, acknowledged that from the stand. When he testified on the stand, he gave yet another different version from what he had given previously to the police. So we had the consciousness of guilt instructions. So that's...
Mr. Barker, did you also present evidence that his lack of physical injury was inconsistent with his description of how the accident occurred?
Yes, that's correct. We did. And that was testified to by Dr. Bollinger. Dr. Bollinger also testified to, and specifically so, that that the lack of injury was inconsistent in addition to the experimentation of Corporal Thierwechter, and also did testify that the injuries on Anne Marie Fitzpatrick were consistent with being held underwater and being drowned. So she did testify to that. Now, the cause of death was drowning in and of itself. And Dr. Bollinger did say, I was not asked to make a manner of death determination. This is suspicious and depends upon further investigation, which did in fact occur.
Counsel, can I follow up on that? Isn't it a problem that the Superior Court conflated, and you seem to conflate harmlessness and sufficiency? In this case, sufficiency, which we weigh everything in favor, the trial judge found against you on sufficiency. Now I realize that was overturned, but it was a really close matter, according to the judge who sat there every day and watched the evidence, and he held it was insufficient. And then after the fact, the Superior Court says, oh, by the way, hearsay, non-hearsay, but if we're wrong, it's harmless anyway. When harmlessness, by contrast to sufficiency, requires a look only at the uncontradicted evidence. How do you confront the failure of the Superior Court to grasp the difference between sufficiency and harmlessness analyses?
Well, I guess the best way for me to put it is we would assert that the uncontradicted evidence in this case supports that the evidence was overwhelming. And by the uncontradicted evidence, we include in that the defendant's statements to the police, which were conflicting and contrary. We focused on primarily what was introduced in our case, and only so much as also was introduced when the defendant testified. Clearly, he was trying to go ahead and contradict evidence. However, those items that contradicted from his past statements would be evidence to support the overwhelming nature. We're not, by asserting that, we're not trying to mix between sufficiency and also the harmlessness standard. We are focusing on the uncontradicted evidence. It was uncontradicted, the massive amounts of motive. It was uncontradicted, his lack of injury to himself. And quite frankly, the manner in which the experiments were occurred, while the defense did try to present their own expert to try to do some refutation, they were not able to refute and did not even attempt to refute the fact that you could not replicate the tire tracks going over based upon the defendant's statements. They were not able to do that. The other additional aspect too, we would note, they never attempted to contradict that the gear shift mechanism on the ATV made his versions impossible. She would have had her foot on the pedal as well as doing multiple maneuvers with the gear shift. That was never attempted to be contradicted as well. So we did factor those aspects in. We did believe the Superior Court did do that, and our attempt and argument was never one to mix sufficiency with the uncontradicted evidence in the case.
Thank you, Mr. Barker. We certainly understand the case, as you can tell from the court's questions, so we'll take it under advisement. And that will conclude our argument for this afternoon.